everyone, and welcome back to the Digital Treasury and Cash Management channel. This next session will be delivered by Kimberly Ann Das, who is the Senior Associate at JC Legal. She will be discussing data protection and risk management essentials. If you have any questions at all for Kimberly, please feel free to submit them into the live discussion box on the right-hand side of your screen. So without further ado, I'd like to pass you over to Kimberly. Over to you.
Greetings and welcome. My name is Kimberly Dassey. I'm a Senior Associate at JC Legal, and we're here to talk about data protection and risk management essentials today. Now, just a quick warning, nothing we talk about here is legal advice, but certainly if you have questions, thoughts, or ideas, feel free to contact us. We'd be happy to help. Our objectives for today are: 1, identify who is covered by the Personal Data Privacy Ordinance, the PDPO. We're going to look at the 6 data protection principles, the DPP, and we'll look at risk areas in cross-border transactions for organizations. Just a couple of slides on that. And finally, we'll look at the best methods to manage data privacy risks. Before we jump in, few points on terminology. You're going to hear these phrases being used throughout the talk, and I want to make sure we're all on the same page. Number 1, a data user is one who controls the collection, the holding, the processing, or use of personal data. So that's going to be the company. There is the next phrase, data subject. A data subject is an individual who is the subject of the personal data. So that is the person from whom you are getting the personal data. So when you ask somebody for their ID card, or you collect a certificate of some sort from them, that is the individual giving you the information about themselves. And finally, this phrase that's used all the time, personal data. Personal data is any information related to an identified or identifiable living human being. And keep in mind, this can also be small pieces of information that when put together, boom, we can figure out who someone is. That's personal data. So first question, who comes under the PDPO? Section 2.1 states that any data relating to a living individual can be used to identify that person and exists in a form in which access or processing is practicable constitutes, quote, personal data, and will be protected under the PDPO and subject to DPP. So if your organization is involved in collecting that kind of information from people, and let's be honest, this is happening in most organizations, your organization will come under the PDPO and be subject to its rules and regulations. We've already talked a little bit about what the definition of personal data is. Here's some more about it. In here, we're using the term the gathering, right? That process of collecting the information about an anonymous subject would not constitute the collection of personal data. So the idea here is data that is identifiable to somebody becomes personal data. But if it's just data that's not identifiable, it's going to be excluded from that definition. So if you are collecting data about people and saving it, you've got to consider whether you are adequately separating that data from the identification of the individual. As it says here, personal data is information about an identified person or a person for whom data collector intended to identify. So it's that question of, are we linking this data to the person? That's when that data will become personal data. We've got a case here, the Eastwick Publisher case. And in this case, we had a magazine who published photographs of women seen in public, talking about fashion sense, etc. The women eventually found out that their photographs had been used, and they complained about it. But in this instance, there was no breach because the data gatherer was indifferent as to the identity of the complainant, the individuals who were complaining in this case. So there was no real link between publishing those pieces of information, those photographs, and then linking them to the identities of those individuals. What are our 6 data protection principles? Let's take a look. Purpose and manner of collection, the accuracy and duration of retention, how you're going to use that data, how securely are you using that data, openness and transparency with the people, with the data subject, and access and correction, the ability to access and correct data. So once you're under the PDPO, these 6 principles come into play for how your company or your organization should manage the information that it is collecting. We're going to look at each one of these individually. First of all, the purpose and manner of collection. Collection of data can be collected for a non-lawful purpose directly related to a data user's function or activity. So, prior to collection, the data subject must be informed before the collection takes place and told the purpose of the collection. So before you ask somebody to give you their personal information, their ID card, information about where they live, etc., you've got to let them know that you are collecting this data and the reason that it's being collected. Second point to note here, data users should duly consider the timing of data collection. So what we're saying here is that the point at which you collect the data is just as important as the collection of the data itself. In this case, an individual made inquiries on course details at a driving school. And to make just that inquiry, he was asked to give his Hong Kong ID card number. There was a complaint about that, and it was heard by the commissioner. And in that case, the decision was made that premature personal data collection prior to course enrollment constitutes a wrongful collection and therefore contravened the first principle, the first data protection principle. So you have to think about when are we collecting it, which ties also into why are we collecting this information. I don't know exactly why this information was collected at this point. You know, a lot of times in these situations, it's going to be for marketing purposes, right? To create a list of people that you can contact, etc. That's not necessarily a legitimate reason, right? So you've got to be careful about the timing as well as what you are collecting. The second point here is on the accuracy and the duration of retention. So 2 points here. The information must be accurate. And the second point here is you've got to specify duration. So the data collected must be accurate and kept only so long as it is needed to fulfill the purpose of the collection. So you have to make sure that you're not holding on to the information too long, right? This gets into a bit of a Goldilocks conundrum, right? We want this collection of data to be just right, not too early, not held on for too long. If data is used by a third-party contractor, that contractor agrees not to keep the data longer than is necessary for the processing of the data. So the company collecting the data, giving it to a third party, has a responsibility to make sure that that third party is managing the data properly. That third party will also be governed under the PDPO. So an example we have here, customers resubscribe to a fixed line telephone service at a new address. Okay, so they've moved, they are changing their address, and the company subsequently sent bills to the old billing address, the prior billing address. So the records were not updated properly. And in this instance, the Data Privacy Commissioner found that the company failed to take all reasonable and practicable steps to ensure accuracy, which contravened the second data privacy principle. So what does that mean for you if you are the data user? Once you collect that information, once you now have it within your system, it's going to be your responsibility to make sure that the information is accurate. I mean, we can see the risk in this situation. A bill gets sent out, somebody else looks at it. Now somebody knows your private information. I mean, a telephone bill is not going to be the most serious infraction there is, but if information is in there that you wouldn't want other people to see, addresses, information about who you're calling, we don't know what's in that bill. There's a risk there of potential identity theft, being embarrassed. Who knows what could happen as a result of that? Maybe not in this particular situation, but we could see it with other types of goods and services that may be purchased. Somebody may be at real risk in that situation. So once you've got the data, you've got to collect it at the right time. You've got to get rid of it at the right time, and you've got to maintain it accurately. Use of data. Personal data shall not be used for a new purpose without consent. Data user must not use the personal data unless the user has reasonable grounds to believe that the use of the data is clearly in the interest of the data subject, right? So companies can get into trouble here because you say, okay, wow, we've got 10,000 records of people who are interested in our product. We're now doing something new, right? Let's send everyone some information about our new product. Well, if you originally collected that data, let's say for the purposes of sending them that product, right? So for making sure that the product arrives at their desired location, if you're now using that information for a new purpose, marketing, you have contravened the third principle of data protection. So our example here, we had an incorporated owners association. They disclosed an owner's name and address on a social network platform to notify all owners of the legal proceedings to which the IO was a party. And you can understand why that might happen. They've instituted legal proceedings, so here's the information. Well, that was challenged. And the commissioner held that the IO, the incorporated owners, only required that they mention that an owner of a flat had made a claim against IO. So in this instance, they should have been more discreet in how they used the data, right? They had all of that information about the incorporated owners and that litigation for litigation purposes. They should have not then transmitted that information on to others for a new purpose. So it was considered by the commissioner to be an unnecessary disclosure of the complainant's personal data in contravention of the third data protection principle. The fourth principle is data security. Data users must protect against unauthorized or accidental access. And this applies to data processors as well. Data processors would be your third-party providers who are often hired to handle these large volumes of data that have been collected. So the example that we have for this is there was a travel agency who distributed a flight itinerary list. So it's a group of people are traveling. The travel agency has come up with the itinerary for the trip and wants to give it to all of the tour members. Well, that email contained all of the tour members' names and their e-ticket numbers, and that was sent to everybody in the group. That's a very common kind of mistake that happens. For example, sending something and CCing everybody rather than BCCing everybody. This information could then be used as a key to unlock sensitive personal data of other members. That's what the commissioner found. So the distribution in this way was unnecessary. And especially in this type of situation, I don't know if there were credit card numbers provided or other personal details along with it. But there's possible risk of personal data leakage. So for you, again, as the data holder, as the entity or organization responsible for collecting the data, you have to be very careful when you transmit that data. So what the travel agency should have done is they could have sent the itinerary list, not had the names in it, not had e-numbers, and sent this out on a BCC basis to the group. Data users are also required to be open and transparent about their data. So all practical steps must be taken to ensure that a person can ascertain the data user's policies and the data user's practices. So as the holder of individuals' personal data, you have to let those individuals know what your policies and practices are as regards their personal data. Here we had an employer who logged into an employee's computer to access her browsing history, and that employer did that without notifying her. So you can see how this would develop, right? The employer feels like, well, this is my computer. The person is working during my time. I'm paying him for his time. I have the right to go in and see what that person is doing on their computer. And who knows, this may have been part of a larger case involving employee misconduct. We don't know at this point. So they were looking into that person's browser history. And there was a complaint about that when it was found out by the employee. Company provided no notice regarding the act in question. The company had not clearly notified the complainant of the purpose of employee monitoring, the monitoring activities that might be taken, or the use of the data collected. So we have to be very careful as an employer when it comes to supervising. Best not to do this unless you're putting people on notice. And I mean, if we think about it in the larger context, rather than sneaking around and doing it as an employer, you let your employees know that this is a possibility, that you'll give them notice, etc. And it's probably going to have an effect of stopping people from using the computer systems wrongfully. So there's probably a better way to manage this particular type of risk other than how the employer chose to do so. So this violated DPP-4. In terms of access and correction, data subjects are entitled to ascertain whether a data user holds personal data of which he is the data subject. Individuals have a right to know how their information is being used and to correct it. Employee, as a data subject, can make a DAR, a data access request, to his employer under the PDPO. The employer has to supply a copy of the employee's personal data within 40 days after that request. And if the employer did not hold the employee's record of service at the time of receiving the DAR, the employer did not need to create such a document for compliance. So this is another example of data access and correction. So we've gone through all 6 of the data privacy principles. What are the consequences of getting it wrong as an employer or as an organization? Could be in order to provide compensation for the breach. There could be fines to the organization. And of course, as a more extreme punishment, there is that risk of imprisonment. We're going to briefly look at cross-border transactions. Just a couple of slides here on that. We don't live, obviously, in a bubble in Hong Kong. We are interacting with the rest of the world. So what are our obligations when we step out of the jurisdiction of Hong Kong into another jurisdiction? Europe, United Kingdom, Australia, New Zealand, and Singapore all have their own data protection ordinances. So if you are going to be transmitting information overseas, you need to be sure that the country that you're transmitting to, you need to be sure what their data protection principles and laws are so that you don't run afoul of them. The current Hong Kong position on cross-border data transfer was published in December 2014. It is a non-binding guidance note. You're still going to be governed by the PDPO, even though your information is going overseas. The transfer, in particular DPP3, the transfer must be for a purpose for which the data was used at the time of the data collection or a directly related purpose. Risk areas and management. So we've talked a little bit about things that can go wrong and different ways to manage those situations. We've got a few slides kind of putting those concepts together. And here we have 1, 2, 3, 4, 5, 6 areas that we believe you should implement in your companies to manage the risks of handling personal data. Communication, contracts, policies, training, documents, technical reasons, technical ways of managing the risk. Let's look at each one. Communication. You've got to ensure that people know why their data is being collected. That has to be communicated to them, and we've discussed that. There has to be a channel for people to have access and the ability to update their data. And once it's updated, the company, the data user, has to make sure that that information is properly stored. And you have to tell people when you may use their data for a new purpose. So before it's used for a new purpose, you've got to let people know. Contracts. You've got to enter into contracts with the recipient organizations or individuals to ensure adequate level of protection to be afforded for the personal data transferred overseas. So that means that when you're transferring the data overseas, the data who is receiving it in the new jurisdiction has to have information and knowledge of how that data should be protected in Hong Kong, as well as in the new jurisdiction. So make sure that you review data transfer agreements and that they are in compliance with Hong Kong law, as well as the laws of the receiving jurisdiction. Policies. Identify a time period for data retention and when the data will be disposed, how it's going to be disposed, as well as when. And of course, then follow those procedures. It's really tempting for organizations to hang on to that data because it is so valuable in terms of marketing, promotion, etc. But that will cause you to run afoul of the law. Draft policies and make them available to employees. We talked about the situation where an employer was looking at surreptitiously the browser history of an employee. That kind of behavior can get you into trouble. I had somebody on a course I taught who said he always insists that employees always give him their passwords so that he can manage and look at what's happening on their emails. This kind of behavior could also fall into that type of risk as well. We would advise against it. Create plans on how to manage data breaches, which means that you have to expect that a breach will occur. Anticipate that that could happen and think in advance of what you might do. Sometimes people will say, well, I don't want to think about it. If a breach happens, I'll just wait until it happens and then respond. Not good enough in this day and age. Breaches can happen to anybody. They happen all the time, and you've got to be on top of how you're going to manage them. Conduct regular audits and inspections on transferees' operations. Training. Train your employees on how to handle data, how to update data. Make sure there's an atmosphere in the organization that allows people to ask questions about data handling. And also, since most organizations probably have some level of cross-border touches, make sure you control cross-border data flow, activities to prevent employees working in offices outside of Hong Kong from accessing or downloading unauthorized data. And in this world today, this moving into a post-COVID world where a lot of people are going to be allowing employees to work from home, and many employees will say, well, fantastic, then I'm gonna move to a cheaper jurisdiction, or I'm going to use this opportunity to wander the world while I'm working from home. We have to be very careful about what our policies are on how data is being transferred and used in those different jurisdictions. Documentation, you've got to keep the inventory of personal data, lock and secure hard copies of documents, passports, licenses, Hong Kong IDs, etc. Keep identity documents with the word copy on them, so we're stamping things appropriately. And lastly, we have here just technical, and this is just a list of all of the risks that we all know about, but many times ignore. Only downloading from trusted sources, keeping your firewalls and systems updated, only sharing data on secure channels, requiring strong passwords and changing those passwords regularly. Too many companies really fail in that area. Every 6 weeks, every 2 months, passwords should be changed and weak passwords should be rejected. Limit use of BYOD and considering hiring an IT staff, although I know for many organizations, full-time staff is not possible. There are organizations out there who will provide you part-time or very casual IT staff. Look into it. That's all from me. Thank you very much for your time. If you have questions, thoughts, or ideas, please let me know.
Thank you very much, Kimberly. That was a really great session and very, very useful. I hope you as the attendees found it just as useful as I did. We will be moving on to the next session very shortly, but in the meantime, please feel free to head over to our exhibition area where you can speak to any of the sponsors we have at today's show. Thank you very much.